Selecting a trustee for your Illinois Revocable Trust. Roles, duties, and best practices. Choosing the right trustee for an Illinois Revocable Living Trust is one of the most important estate planning decisions. Too often people treat the appointment as an honor for a loved one, but state law regards it as a fiduciary role with significant legal and financial obligations. A successor trustee who takes over when you become incapacitated or die assumes control of your assets and must act solely in the beneficiary's interests. Experienced Chicago attorneys help clients structure trusts so these responsibilities are understood and fulfilled. The Illinois Trust Code requires trustees to take inventory of assets, secure property, manage accounts, invest prudently, keep thorough records, file and pay taxes, keep beneficiaries informed and distribute assets according to the trust document. Serving as trustee demands time and diligence, it is not honorary. Trustees owe 4 specific duties: loyalty, prudence, impartiality, and a duty to inform an account. Loyalty means administering the trust for the beneficiaries and avoiding self-dealing. Prudence holds trustees to the standards of a prudent investor, emphasizing diversification and long-term stability regardless of personal experience. Impartiality requires equal regard for multiple beneficiaries, which can be difficult in blended families with competing interests. The duty to inform an account obliges trustees to keep beneficiaries up to date and provide regular statements. There are 3 basic ways to structure who will serve. Appointing an individual, such as a spouse or adult child, offers personal familiarity and may seem inexpensive, but individual trustees often lack legal, tax, and investment expertise, face emotional pressure from beneficiaries, and risk conflicts of interest. Choosing a corporate trustee, like a bank or trust company, brings professional expertise, impartiality, and continuity, though fees and formality can feel impersonal. A hybrid arrangement names an individual and a corporate co-trustee together so each can contribute their strengths. In a hybrid, the corporate trustee typically handles investment management, accounting, and tax duties, while the individual provides personal insight on the family's needs. Estate planning lawyers routinely see mistakes in trustee selection. Naming a beneficiary as sole trustee places that person in a conflict between their own inheritance and their fiduciary duties. If a beneficiary trustee can distribute assets to themselves beyond an ascertainable standard such as health, education, maintenance and support, tax and fairness issues may arise. Appointing 2 individuals as co-trustees can also backfire because Illinois law requires majority decisions. 2 co-trustees can deadlock over sales or payments, forcing litigation. Another common error is failing to name successor trustees, which can leave a trust leaderless if the first choice dies, becomes incapacitated, or refuses to serve. A hybrid model often offers the best protection for blended families or estates with complex assets. Under Illinois law, a corporate co-trustee usually has custody of trust assets unless all trustees agree otherwise, so responsibilities can be allocated clearly. When beneficiaries request distributions, the corporate trustee decides based on the trust terms, insulating the family co-trustee from emotional conflicts. By combining personal understanding with professional compliance, a hybrid helps maintain family relationships and reduce errors. An effective trust goes beyond naming a trustee. The document should define the trustee's powers, set distribution standards, and identify at least 2 successor trustees. A knowledgeable attorney can tailor these provisions to your circumstances and ensure compliance with Illinois law. Whether your trust holds a primary residence, investment property, or other assets, proper drafting avoids costly disputes later. Selecting a trustee is a critical step in creating or updating a revocable trust. Whether you choose an individual, a corporate trustee, or both, the trustee must understand their duties and be prepared to devote the necessary time and care. With careful planning, you can avoid common mistakes, protect your legacy, and ensure that your estate plan works as intended. For assistance, contact Illinois Estate Law at 4422 North Ravenswood Avenue Suite 212, Chicago, Illinois, 60640, or call 312-373-0731. Their attorneys provide guidance tailored to families throughout Chicago and nearby suburbs to ensure your revocable trust protects your assets, honors your intentions, and brings peace of mind to your loved ones.